We have a viewer from Goldsboro who sends us an email, and this email is, I know people who have already pre-leased their land to gas companies. They have been approached long before it was legal to drill in this way. Does this make these agreements void, or have they already lost their rights?
So I can address part of that. I suspect all of us might want to say something. It doesn't, the state bill will not make that agreement null and void. But I would like to talk a little bit about what homeowners can do and should do in this situation. So the first recommendation is for homeowners to be sure you do your homework. And what I mean by that is everything from, first of all, checking what the status of your mineral rights are. I sampled a homeowner last week in Pennsylvania. They were in their home for 35 years, a couple. They assumed that they owned 100% of their mineral rights, and in fact they didn't. The previous owner retained 50% mineral rights, sold those rights out from under them, and this couple was heartbroken. So check your mineral rights. Get your well tested. If you're on a water well, a private well, get that well tested before drilling comes to you, even if it means you have to pay for it, so that if there's a problem, you have a baseline that's been tested and you have a foundation for that. And then finally, do your homework when those gas company representatives or leasing companies come knocking on your door. Don't sign up for the first person who comes on to your door. Don't sign up for $100 an acre. Don't sign a lease that absolves companies of liability if you have a problem. And above all, don't sign a lease where you assume responsibility if a problem occurs. Be very, very careful. Do your homework.
Okay. I mean, right at about 9,000 acres has been leased in Sanford in Lee County. And in that Sanford subbasin, it's about 800 and some odd groups that have signed on to get these leases in here. The biggest problem I've had from the Geological Survey perspective has been, I don't know what the lease says. We have a memorandum of a lease, or we have a memorandum of an agency agreement. You're serving as agent for somebody to pool their information or pool their resources together. So I don't know what they're getting. It's for $1 and other considerations thereof. I have no idea whether they're getting $100 an acre or $2. And that's one of the key things we come down to it. We work with the Secretary of State's office to make sure that these companies are registered as they're supposed to be registered on the rules. So a couple of weeks ago, rather than have the Secretary of State's office staff look up all the stuff that I've looked up, I just gave them my 4.5-inch thick sheath of all the lease statements I had for Stanford and just said, you borrow them as long as you need them. Make copies if you want to. Give them back to me when you're finished with them. Just so they wouldn't have to waste the time of having to go onto the website and pull each individual lease down from that. So, I look at there and see there are clearly leases back from years ago that are clearly not right. It says, for example, you can use your well for storing gas from some other location. That's not allowed in North Carolina. Well, those kind of things we have to look at there and see. So some of these leases may not be valid. Some leases might have problems. But one of the key things sometimes is that you signed it. And, that's the problem about it. I mean, if someone asked me what's the best thing I could do about a lease, would be have a lawyer look at it that's got experience in oil and gas issues.